And so it's always really, I always have a fun conversation with groups like this, and so I'm really looking forward to talking to you for about 45 minutes, I hope, and then opening up and having a conversation, questions and answers, or however you want to take it. What I want to do is, in the talk, is to assess where we are right now with the courts and the First Amendment. Specifically, the Establishment Clause of the First Amendment, which is the key provision that limits government support of religion, and which therefore is of, I think, particular importance to non-religious people who want to feel included in the public life of the country. And I'm going to suggest that the conservative Supreme Court that we have these days, and the courts that are following it, the lower courts that follow it, have brought us closer and closer to conditions that make it right for Christian nationalism, which should obviously be concerning to those of us who consider us to be secularists or humanists or religious minorities of any kind, really. And so my plan this morning is, or not this morning, the plan this afternoon is to briefly trace the historical evolution of the Supreme Court's treatment of the Establishment Clause from what I'll call kind of separationism in the 1970s and 1980s to what I refer to as post-separationism with a side of pluralism in the past 20 to 25 years, to where we are now as a result of some cases and decisions in just the past few years, which have left us, I think, at a critical juncture for religious equality and pluralism in the United States. So, first of all, I want to make just a couple of basic points about the Constitution and the Supreme Court's doctrine. The first thing is the text of the First Amendment. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. 16 words with a long history of debate and dispute about what they mean. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. And so there are two parts there. There's the Free Exercise Clause part, and there's the Establishment Clause part. The Free Exercise Clause part is about protecting, to some degree, religious believers' right to practice their religion as against government attempts to restrict that practice. Whereas the Establishment Clause is about placing limits on government's authority or ability to support religion in some ways. The Free Exercise Clause is important. And it's actually changing right now very quickly also to be much friendlier to religion. I'm not going to talk too much about it because of the time that we have, a limited amount of time that we have. But we could talk about the Free Exercise Clause in the question and answer section if you want to. I'll tell you that my bottom line on it is that I know that lots of non-religious people are worried about the court's free exercise doctrine. I actually support robust religious freedom rights under the Free Exercise Clause, but I also think that they have to be paired with a strong version of the Establishment Clause that limits the government's authority to support religion in public life, or otherwise the First Amendment becomes out of balance, which I believe it is right now. In other words, what I think the problem with the Free Exercise Clause is currently is the court's view of the Establishment Clause. So I can't talk much about the Free Exercise Clause, but I want to get right into the Establishment Clause and go to that, and then if we want to come back to the Free Exercise Clause later, we can. Up until June 2022, the Supreme Court used what it called the Lemon Test to evaluate Establishment Clause claims. And the Lemon Test came from a 1971 case involving this guy named Lemon, and it says basically, the test does, that a law would be held unconstitutional if it either has a predominantly religious purpose or if it had the primary effect of promoting religion. So either predominant religious purpose or the primary effect of promoting religion would render a law unconstitutional under this Lemon Test. The religious purpose test, however, rarely played a role in the court's decisions because usually the government could come up with some secular purpose to justify its law in addition to possibly a religious one. So there are 4 or 5 cases in which the Supreme Court decided a case based on the religious purpose. Once there was this case called Wallace versus Jaffrey, which was about a moment of silence law from Alabama. And basically what happened in that case was the government had this moment of silence law that said that every morning the school would start off with a moment of silence so that people could could engage in meditation or whatever they wanted. And then they Alabama tried to amend the law to say, or prayer, like meditation or prayer. And when asked on the stand what the purpose of the law was, the legislator said, to promote religion. To which the lawyer said, was there any other reason? And the legislator said, no, that was the reason, to promote religion. And so in that weird case, the Supreme Court said that was a religious purpose, and it was unconstitutional. Actually, moment of silence laws tend to be fine, but in that case, it was unconstitutional because it was the rare case where the government simply asserted that it had nothing really but a religious purpose. But usually, religious purpose didn't matter. So the case has always turned on this advancement or promotion of religion. But that test is always too vague and too abstract to kind of straightforwardly apply in the wide variety of contexts in which Establishment Clause cases came up. So the court, what does advancement or promotion of religion mean in the abstract? It's kind of hard to tell. So the court used that concept, but it used it in different ways in different doctrinal, in different factual contexts. In other words, this Lemon test, which said the government can't act with a primary factor of promoting religion, manifested itself in different ways in different types or categories of cases. And so I want to talk about three of those contexts today to kind of keep our discussion kind of limited. And I want to talk about how the court has evolved in its treatment in those three contexts. And the contexts are as follows. First of all, the placement of religious symbols or displays on government property. Lots of cases over many years about can the government put up a cross on public property? Can the government put up the Ten Commandments on public property? How about a creche at Christmas time, etc.? So that's the first context. The second context is government funding of religion, especially religious schools. When can the government send money one way or the other to religious schools or help religious schools in some way? That has a long history, and I'll talk about how the court has changed in its approach to that issue. And then finally, the third context is government-sponsored prayers, right? Either in public schools or before public bodies like town boards or legislatures. When can the government start off a meeting, for example, a town board meeting or a legislative session with a prayer? You may or may not know that I bet you do know, that the United States House of Representatives and Senate starts every session off with a prayer. So whenever anybody says, how about the separation of church and state in America? I always say, well, yeah, our most important legislative bodies start every session off with a prayer. So not sure about that. But anyway, so we'll talk about that. And what I want to do is describe how the court's approach to each of those three contexts changed from the 1970s, 1980s kind of separationist era to the more modern approach, which I've called post-separation with a pluralism side order, the side order of pluralism, of the earliest 21st century. And then, when I'm done with that, we'll move on to the last few years. Okay, so that's where I'm going. Okay, so first, let's start with the 1970s and 80s and talk about the court's approach to these symbols or displays cases. Back in those days, the court followed this thing called the endorsement test, which was a creation of Justice Sandra Day O'Connor, who I miss more and more every day, I have to say. Even though I didn't always agree with her when she was on the court, she always had this. She would always do she would balance the factors, and she didn't have these strict rules on everything. So sometimes you were always disappointed, but you always had a chance for the next case. And we have very little of that these days at the court. So I don't know, I'm just missing Justice O'Connor a little bit. But anyways, the endorsement test said that if a reasonable observer looking at a religious symbol on government property would feel that the government was sending a message a message of endorsement of religion, then the display or symbol was unconstitutional. Basically, the question asked, would a reasonable observer think that they were being made to be who was not part of the religion that the display was about? Would they feel like they were disfavored or excluded from the public square or not? And sometimes the government would win on those cases, and sometimes the government would lose. So, for example, there was a case where there was a creche by itself on a courthouse staircase in Pittsburgh. The court said that was unconstitutional because having a creche just by itself was basically an endorsement of Christianity, and any reasonable observer would understand it as so. On the other hand, there were cases that came out the other way, kind of frustratingly to somebody who was not a Christian. For example, in a case called Lynch versus Donnelly, which was out of Rhode Island, Pawtucket, Rhode Island had this nativity scene with a creche on public property, but it was surrounded by other things like a candy cane, a big candy cane, and an elephant, and some reindeer. And so the Supreme Court looked at that and said, well, a reasonable person would look at that and say, oh, that's just a kind of celebration of the season and not an endorsement of religion. So bottom line, the court applied the endorsement test in that, and sometimes the government won, sometimes the government lost, sometimes religious displays were okay, sometimes they weren't. In the modern era, however, the court has radically weakened the endorsement test, such that the government really almost always had won. It's been nearly 20 years since the government has lost an Establishment Clause case, as it turns out. A few years ago, there was this case you might remember from Maryland, which involved a 40-foot cross on public property in Bladensburg, Maryland, I think it was. And I just knew the court was going to find that was okay, but I had to go down and watch the Supreme Court argument just out of some sort of, I don't know, masochistic urge or something. So I went down there and I watched them debate for 40 minutes about whether a cross was a religious symbol or not. Turns out it's not, so don't worry. But anyway, so the endorsement test radically weakened in the modern era, such that the government was able to put up almost any kind of religious symbol on public property, though it was still the case that the government couldn't put up just a regular old. So that was the 40-foot cross was part of a World War I display celebrating. Honoring World War I veterans. And so the idea that the court had was this wasn't a religious symbol so much as a symbol to honor the dead, and that's why it wasn't an endorsement of religion. But a regular cross on public property still probably not okay during that era. Okay? So that's the symbols and displays context. Second context, government funding of religion, usually about funding of religious schools that teach the truth of religion, right? Back in the 70s and 80s, the court used this kind of detailed, sensitive inquiry, case by case, into the amount of funding and the nature of the funding that was at issue in order to decide whether it went too far in subsidizing religion. So there were really no clear rules back in this era, and so the court here heard case after case, like two dozen cases maybe, and sometimes they came out in favor of the aid, and sometimes they came out against the aid. And oftentimes the decisions were hard to reconcile with each other. But I would say this, there was no question during this era that the government could not just simply fund religious schools. The questions were always about smaller things, like could the government pay for books that were used at religious schools? Or could the government fund the busing of students to private schools if those private schools happen to include religious schools as well? And sometimes the court would say yes, and sometimes they'd say no. For example, they said it was okay for the government to pay for students to take buses, public buses, to a religious school, but not to use public buses to go on field trips from the religious school. It was kind of a curious distinction, which maybe didn't make any sense. But the basic point I'm trying to get at is that sometimes these pieces of funding were okay, sometimes they weren't okay, and it was never the possibility during this period that the government could simply fund religious schools. These days, a much simpler rule, which is which basically approves of most government funding of religion. And so the rule is basically, as long as the government gives money to an individual who then decides where to spend that money from among a group of possible recipients that includes both religious ones and non-religious ones, then the program is okay. So in other words, a voucher program, which is the paradigmatic example of that kind of arrangement. Those are okay. The government gives money to parents. The parents have basically a check, and they can decide where to use that check to send their kids to private schools. And they could choose a secular private school, they could choose a religious private school, but it's the parent's choice. And the court says, as long as it's that private choice and the government's not sending the money directly to the school, then it's okay. Even though all the money in those programs goes to religious schools, and almost all of the money that goes to religious schools goes to Christian schools, Catholic schools usually, though not entirely. So that's why we have a huge billions probably of dollars that go to religious schools. It's a result of the Supreme Court's decision in this voucher context. So it's a simpler rule now, but it means that there's a lot more money, tons more money going from the government to religious schools. Third context is the government-sponsored prayer situation, which is we're either talking about public schools, or we're talking about legislative prayers or prayers before the town boards, things like that. In the 70s and 80s, the court came up with this thing called the coercion test, which was part of the Lemon test, I think, although the court was never quite clear. It was like Lemon was at the top, endorsement was one version of it, and the coercion was another version of it, and it was the coercion test that was used in this context of funding, of government-sponsored prayers in schools. And we know that the court in the 60s said basically no government-sponsored prayers in school. And the court extended that as late as almost, I think to 2000, in context involving public school graduations. There was one case involving a public school football game in Texas, where the court said that a prayer program that was involved in that the school in Texas had adopted was unconstitutional. So the court was kind of strong on this coercion idea, at least with students. Recently, the court has really weakened this coercion inquiry. Not so much in the public school context yet, though I would guess that that's coming, and I'll talk about that soon. But at least in the legislative prayer context, the court has been very solicitous of towns and legislative bodies that want to start off their session with a prayer. Big case was called Town of Greece. It came from Town of Greece versus Galloway was the name of the case. Comes from a small town up near Rochester, New York, that started basically for 2 years. This town started every meeting of the town board off with a Christian prayer. And one atheist humanist, Linda Stevens, true hero in my view, as well as a Jewish plaintiff, brought a lawsuit against the town. Case went to the Supreme Court, and the Supreme Court said it's fine. Start off with a prayer if you want to. There was an argument that this was coercive, right? Because if you go to a town board, you have a zoning issue before the board coming up in 5 minutes, right? You're a humanist. The board says, okay, now let us pray, with this person that we invited to pray. And the prayer, is a Christian prayer. You have the zoning case coming up in 5 minutes. What are you going to do, right? I mean, hopefully you will just sit there, do nothing. But the pressure to kind of stand and participate in the prayer in some way, I think is quite strong. And that was the argument, one of the arguments that the challengers made. Justice Kagan accepted that in a brilliant opinion, which happened to be a dissent. But the majority of the court said, people can leave if they don't want to pray. They can sit, they're adults, although not all people at these town meetings are adults. Don't worry about it. There's no coercion going on in this context. It's fine. Okay, so we've had a weakening of the Establishment Clause in each of these three contexts: the symbols and displays context, the funding of religion context, and the government-sponsored prayer context. Leading up to, let's say we're about at 2019. I'm about at 2019 in my story. And that was the year that I published this book called Our Non-Christian Nation. And what I talked about in that book was that while those developments that I just described were problematic and concerning to me and to others who are religious minorities, including humanists, at least the court kept the idea that the government could not discriminate among religions when it was giving out its benefits, right? So in other words, if the government's going to support religion generally, it has to include all religions. It can't just promote Christianity. It has to allow everybody to have at least theoretical access to government money, government property, and other resources. So, for example, a town couldn't, create a program that would pay parents to send their kids to Christian schools, but not Jewish schools, for example. And this pluralism also, I think, included versions of secular or humanist belief systems that took an active position on the same questions that traditional religions did, right? Which, in other words, I think atheism was a religion for these purposes, at least, right? In other words, because atheism or humanism or secularism seeks to answer some of the same questions that religion answers or seeks to answer. Therefore, it's in the same category as religion. And so if the government supports religion through money or property, it also has to support non-religion of that sort through money or property or whatever. So a good example of this was in this Town of Greece decision that I talked about. Justice Kennedy, who wrote the majority opinion, nonetheless made it clear that a town could not discriminate against religion, certain religions, when implementing its town board prayer program. And as a result of that, as I talk about in my book, religious minorities, including secularists, took full advantage. They seized on that sentence in Justice Kennedy's opinion and started asking town boards and legislatures, more than they had already, if they could give invocations before, to start off the prayer, and start off the meeting, or start off the legislative session. And all over the place, including very conservative places like Central Florida, secularists and religious minorities like Wiccans and Satanists gave invocations before public bodies. Moreover, minority religious groups also applied for government money and got it a lot of times. There are a few Muslim voucher schools that receive money, although it's interesting. Sometimes when a legislator learns that there are Muslim schools that are going to benefit from the funding in addition to Christian schools, they go, oh, well, let's shut that voucher program right down then. That has happened several times. Maybe unsurprisingly, if so, it's disturbingly so. But that happened. And then also in the symbols and displays context, governments wore, in the symbols and displays context, governments kind of created these what are called limited public forums for religious use. So remember I said, even though you can put up a 40-foot cross for the war dead of World War I, you still can't put up just a plain old unadorned cross on public property as of this period. So what would happen would be somebody would put a cross up on, or the government would put up a cross on public property, somebody would object, and then the government would say, okay, fine, we'll set up a limited public forum for private speech, which is something the government could do. It could say, all right, in this little area, individuals of all sorts who are religious or non-religious could put up their symbols or displays, and they can stay there. It's sort of like a place where everybody gets to say what they want. The government's not really endorsing that because it's just opening up a forum for private speech. And this happened all over the place. And so Satanists, Wiccans, secularists would put up their symbols next to the Christian symbols that were put up. The Freedom of Religion Foundation, which I hope you are familiar with, a marvelous organization from Madison, Wisconsin, put up their secular holiday display in state houses all over the country. Their display was basically a Statue of Liberty hanging out with George Washington and Thomas Jefferson, and they're looking over a manger which has the Bill of Rights in it instead of baby Jesus. And they put that up all over the place. And so in my book, I described all this movement, right? We're post-separationism. The government can support religion, but the government, still can't discriminate on the basis of religion. And so religious minorities, including atheists, secularists, humanists, are sort of taking part in this pluralism and putting up their symbols on public property and starting town meetings with their invitations, etc. And I said, well, that's a good second best kind of thing. Like, I'd like to have separationism, but if we can't have separationism, at least we can have this nod to pluralism. Okay. That was 2019. Past few years, even this pluralism part is coming under threat. Which in a country that's still mostly Christian, of course, means we're moving further and further to a public square that can be devoted exclusively to Christianity. And so now I want to take each of the three areas I've talked about and talk about how between some Supreme Court decisions and lower court decisions following along with those Supreme Court decisions, we're starting to tiptoe towards this situation ripe for Christian nationalism. So, how did this all happen? Let's see okay. Let's start with the religious symbols and displays context. Okay. In June of 22, the court decided this case called Kennedy versus Bremerton School District, which I bet you've heard about. It's the state of Washington football coach case. In this case, the court got rid of the lemon test. It never liked the lemon test. Many of the justices never liked the lemon test, but they hadn't gotten rid of it yet until this 22 case involving the coach. The facts of that case are basically a football coach. It's hard to describe the facts of this case because the majority of the dissent had completely different versions of what happened, which itself is a huge problem, but because there's a record in the case, and so it either happened or it didn't. But anyway, the football coach was fired by the school district for his religious activity during games. That part was clear. According to the coach and to the majority of the Supreme Court, all he was really doing was basically kneeling for a quick private prayer on the 50-yard line after games. That's all he was doing. According to the school and to the dissenters in the case, Justice Sotomayor wrote this blistering dissent with pictures. According to them, this coach was fined not just for making little private prayers at the 50-yard line by himself, but for a whole package of stuff, including leading prayers in the locker room and at the 50-yard line, not by himself, but with both teams surrounding him and kneeling around him. And there's pictures of that in Justice Sotomayor's dissent. He's there. Both teams are around him. They're all kneeling. He's praying. The school said they had to fire the coach because otherwise the government would be endorsing religion and also coercing students to pray. Because, right, who's going to get the playing time is the idea. The Christian linebacker who's praying next to the coach, or the humanist linebacker who's like sitting it out on the sideline, right? So the pressure, and here there are kids, and the court is always worried about coercion of kids until 2022. And so there was, I think, a very strong endorsement argument and a very strong coercion argument in the case. The court, however, held 6-3 for the coach. And it did three things in the case. First of all, it manipulated the facts, as already mentioned. We'll just leave it at that. Second is it engaged in this very weak coercion analysis that I just described, right? I'm not even sure there is a coercion test anymore. It's a little unclear. But in any event, it's even weaker than it was in the town of Greece case as a result of this football case. And then third, of course, as I mentioned, it discarded the lemon test and the endorsement test with it, replacing it with something called the historical practices and understandings test. The original meaning and history, that's Gorsuch's language. Whatever that means, that's what they replaced it with. So that's what the court's supposed to do, look to whether whatever's being challenged had historical practice, a precedent or something like that. And so that decision opens up the door for government preference for Christianity for three different reasons. First of all, if the lemon test is gone, then the religious purpose test is gone. And although it's true that, as I said, that the religious purpose test didn't do a lot in most cases, it still did something. And so now the government can act with a religious purpose all at once, unless the court makes up something later that says it can't. But that seems to be the case. And what purpose is a government policy likely to represent? The satanic purpose? the atheist purpose or the Christian purpose, right? So that is a problem right there. Second is this historical approach, whatever that is also inherently favorable to Christianity, given our history, right? We have a long history of Christian majorities in the United States, right? So we don't have a long satanic history or wicked history. I mean, maybe some, but nothing compared to the Christian history. And then third, and I don't know if it's most important, but I'll talk about it more. Seemingly, when the court got rid of the endorsement test, there's now no real limits to the government setting up religious symbols on public property. And there's no incentive for the government to create these public fora for private speech that were critical to the pluralism story that I was telling earlier. And in fact, this has happened. So an example from Texas, in a case called Freedom from Religion Foundation versus Abbott. In 2016, Texas put up a nativity scene in the Capitol in Austin, but it was part of a public forum, right? So the Texas government set up a public forum at the Capitol. They put up the nativity scene. Then the Freedom from Religion Foundation came along and they put up its display. And then the governor said, take down the Freedom from Religion Foundation display. And they did. And the case went up to the Fifth Circuit Court of Appeals, which said that's unconstitutional. That was 2020. So after that, Texas decided, we'll close the public forum. And we'll say that all the displays that we put up at this Capitol are all the government's speech. Not private individual speech, but the government's speech. And so therefore the state can decide what goes up and what doesn't. That would have been unconstitutional previously, but now it's probably not unconstitutional because the endorsement test is gone. And so when the case went back to the Fifth Circuit in 2023, very recently, the court just dismissed the case as being moot, and because there was no public forum anymore. And basically the result is the state of Texas can now put up its nativity scene or whatever Christian symbol it wants at the Capitol without any need to allow access to any other religious group's symbol or display. And I think that's a direct result of the court's Bremerton decision, which got rid of the endorsement test. Okay. So that's public displays and symbols. Moving on to government funding of religion, I want to talk about this, and then the invocation, and then I'll wrap up, and then we'll open to questions. So, government funding of religion. First of all, I want to note that unlike displays and the prayer context, pluralism is a lot harder with government money because the scale is bigger. Right? I mean, what I mean by that is, yes, religious minorities can get money for smallish programs like running a soup kitchen, for example, or running a substance abuse program. But the real issue is schools, right? The government can fund all these religious schools. Those schools are almost all Christian. There aren't any, much as I'd love to have an atheist school, like not a school which is criticized by religious people as being secularist, but an actual atheist school which teaches that there is no God. Let me just think about that for a minute. Okay, right. It starts off every day not with a prayer to God, but with a celebration of no God. So that school is probably not going to exist. I don't know, maybe it's more likely to have that kind of school than, for example, probably a Buddhist school. When I was researching my first book, which was in 2007 or something, I went out to Cleveland, which was where this voucher case in the Supreme Court came from, and I purposely wanted to go around and meet the Buddhist community to ask if they could come up with a school, because they could get money for a Buddhist voucher school if they wanted to, and they were like. I met with a number of Buddhists, and they said, we can't even get ourselves together to have a softball game. I don't think we're going to be making a school anytime soon. So, right, it takes a lot of money, resources, and people to make a school, one school, much less 20 schools to compete with the Christian schools who are receiving all this money. So, basic point is it's really hard in the money context to have an equal playing field of pluralism. But the court has made it even harder or worse in the past few years. Most importantly, in a 2020 case called Espinoza, the court said not only can the government include religious schools as part of its voucher program, but as a matter of the free exercise clause, it's a discrimination to exclude religious programs from religious schools from those programs, right? So some states had said, okay, we'll set up a voucher program, but the money will only go to private secular schools and not religious schools. And the Supreme Court said, no, if you're going to set up a voucher program like that, you have to include the religious schools. Otherwise, you're discriminating against religion. And so, as a result, states can't even restrict their public funding of private religious schools if they wanted to, if they set up a voucher program in the first place. So, and soon, within the next few years, I bet, the court is going to decide whether this principle applies to charter schools. Because in Oklahoma, there's a new charter school which is religious, and that's going up to the courts in Oklahoma. And at some point, it will make it to the Supreme Court. And I think if you follow the rationale that the court's been using, the court will say charter schools can be religious also. Okay, finally, government-sponsored prayer. Right? Remember I said the Supreme Court has said government bodies can start their meetings off with a prayer or an invocation as long as they don't discriminate about who can come and pray. In other words, if a town has some procedure where people apply or request to come give their invocation, the town can't say, oh, we're only going to allow Christians to give an invocation and not others. And as a result, lots of minority members have gone, minority invocations have occurred over the last 5 to 7 years all over the country. But 3 developments in the lower courts, I'm sure building on what they believe the Supreme Court is up to, have cut away at this pluralism. And one of those, which I'll end with in a moment, is from right here in Boston. Well, not right here in Boston, but there, somewhere in Boston. So what are these 3 developments? First of all, the first development is the exclusion of atheists from prayer programs. So several jurisdictions, including the U.S. House of Representatives, have excluded atheists from giving invocations on the basis that they're not praying, right? So it's a government prayer program. Atheists, secularists, humanists don't pray, so they don't have to be included. This kind of policy has gone up to 2 federal circuit courts, the D.C. Circuit and the 3rd Circuit, which is in Pennsylvania and New Jersey. And both of those courts have upheld these policies of excluding atheists using historical analysis, right? We've had long history of prayers starting off legislative sessions, and they've never involved atheists, so then therefore it's okay to exclude atheists. It's the historical principle used to exclude religious minorities. Second strategy to reduce pluralism in this space is using ties to the city or community to exclude people from giving invocations. So in Scottsdale, Arizona, the Satanic Temple asked to give an invocation. The Satanic Temple, which was born basically in Cambridge, now is in Salem. We can talk more about them if you'd like in the Q&A. But they asked to give an invocation in Scottsdale, and the city said no. Yes, we start off our town meetings with prayers, but you can't do it. You can't have one. And the reason the Satanic Temple can't give an invocation is not because the city doesn't like Satanists, though that's the real reason, but rather because they said the Satanic Temple had no substantial ties to the city, and the city's policy is only to allow people with ties to the city to give the invocation. No matter that the mayor and the city councilwoman had said really nasty things about the Satanic Temple that made it clear that they were being discriminated against, the Ninth Circuit Court of Appeals in 2020 said it was okay for Scottsdale to exclude the Satanic Temple. Which brings us to Boston, which has used its policy of allowing city councilors to invite their friends to give invocations as a justification for excluding, once again, the Satanic Temple. So the Satanic Temple has asked the Boston City Council for many years if it could give an invocation before, one of its meetings. The City Council in Boston starts every meeting off with some sort of invocation. What happens is that the City Council person, they rotate, and that each month or whatever, a new City Councilor gets to pick somebody invite somebody to give an invocation. And, who are they going to choose? They'll choose somebody from their, that they like, maybe that they know, somebody who's done something good for their community, which, that's good and all. Of course, nobody ever invited the Satanic Temple. And so they said, well, nobody invited you, so you can't give an invocation. City Councilor George, when asked about this, said something like, it's absurd that the Satanic Temple would want to give an invocation before the Boston City Council. It's an abuse. I wish I could remember exactly what she said, but she said mean stuff about the Satanic Temple. Anyways, the case went to the district court, and the district court said, held for the city council, said that the Satanic Temple's discrimination claim was not valid because the policy was to invite their friends, and you're not their friends, basically. So that's a little harsh, a little bit like maybe I'm being a little snarky on that, but I think that's roughly what the Boston City Council and the court did. The case will go to the First Circuit Court of Appeals at some point in the next year, and we'll see what they say. But I bet, given Supreme Court precedent, the Satanic Temple will lose again. So if you put all of this together, and basically this whole movement of pluralism in the invocation area, which I was so excited about in 2019, is drying up. It still exists. Some atheists are still giving invocations, but these new strategies to exclude atheists and non-Christians are really risking the possibility that all we're going to have from now on are really Christian invocations. And then the final thing I'll say is, what about school prayer? It's still prohibited, but given the court's loosening of this coercion test, I would not be surprised if some of those cases, some of those famous cases from the 60s, end up getting overturned. I mean, we know that the Supreme Court really, really cares about precedent. So I wouldn't worry, so I'm not, I'm worried about that. Those cases haven't come up yet, but they could, and I'm worried about what will happen when the court says, well, the kid's not going to be coerced by the football coach. Why would they be coerced by the teacher or the graduation speaker or something like that? It's pretty worrying. So the basic message here is that things have changed since 2019. In just 4 or 5 years, we've seen a retreat from the pluralism that the court seemed to be protecting as of the end of the 20-teens. And I worry that all of these developments in these three spaces, the money, the public displays, and the invocations before government meetings, are all going to close up. They're all going to close up to religious minorities, including humanists, as a result of the judiciary, particularly the Supreme Court's failure to recognize the impacts of its jurisprudence on minority rights, on the beliefs of minority religious people, whether they're humanists or Wiccans or Satanists or Buddhists or whatever. And so that's a sad message to leave you with. I wrote Happy Sunday. But that's all I've got. I have no hopeful message. Thank you.
Thank you very much.